Laws that govern paramedics differ marginally from state to state in Australia, and more so between countries. This video essay will address a case of misconduct involving the Scottish Ambulance Service as if it occurred in Queensland, in an effort to better understand the laws graduating QUT paramedics may eventually be governed by. In 2016, Scottish paramedic Daniel Lauder left the primary care of a patient involved in a road traffic collision to a student technician whilst en route to hospital. Meanwhile, he failed to complete adequate clinical observations. Mr. Lauder also claimed to be a mentor despite having been taken off the mentor list. He then informed the patient's general practitioner of the patient's reluctance to be admitted into hospital, when this was in fact not the case. Historically, Mr. Lauder once again failed to obtain a full set of observations from a patient and record them, resulting in no oxygen being delivered to a hypoxic patient. The Health and Care Professions Tribunal Service found that Mr. Lauder's actions constituted misconduct, and he was subsequently stood down to an ambulance technician role. But what would have happened had Mr. Lauder been employed in Queensland as a paramedic instead? Brogan defined misconduct as wrongful, improper, or unlawful conduct motivated by premeditated or unlawful intentional purpose or by obstinate indifference to the consequences of one's act. It includes any unacceptable or improper behaviour for a professional person. Under the Queensland Ambulance Service's discipline policy, disgraceful or improper conduct in an official capacity constitutes misconduct. In Queensland, the governing body is the Australian Health Practitioner Regulation Agency, or AHPRA. Mr. Lauder's fitness to practice would have been investigated and critiqued by this body. Fitness to practice relates to a person's skills, knowledge, health and character, and how those attributes influence their ability to provide adequate care. The relevant legislation is designed to protect the public as well as enforce any codes set in place by organisations such as AHPRA and QAS. This is illustrated in the Public Sector Ethics Act, Queensland 1994, Section 12H. Compliance with Code and Standard of Practice. A public official of a public service agency must comply with the Code of Conduct for public service agencies and any standard of practice that applies to the official. Had Mr. Lauder been a QAS employee, he would have committed several Code of Conduct violations under AHPRA's Code of Conduct for registered health practitioners. Mr. Lauder failed to practice with professionalism, and consideration for the patient's best interest was not evident in his care. His professional conduct was significantly lacking, as evident by his dishonesty and absence of empathy, more specifically seen in Section 3.2, Section 8.8 and Section 10.2. Additionally, referencing Mr. Lauder's failure to supervise and properly educate his student technician, he clearly dismissed any responsibility for overseeing the student's interventions and clinical skills. Accumulating to this, Mr. Lauder was also not approved for a mentoring position. The Public Service Act, Queensland 2008, Section 187 outlines what behaviour constitutes discipline. A public service employee's chief executive may discipline the employee if the chief executive is reasonably satisfied the employee has performed the employee's duties carelessly, incompetently or inefficiently, been guilty of misconduct, contravened without reasonable excuse a provision of this Act, contravened without reasonable excuse a standard of conduct applying to the employee under an approved Code of Conduct under the Public Sector Ethics Act 1994, or contravened without reasonable excuse a standard of conduct, if any, applying to the employee under an approved standard of practice under the Public Sector Ethics Act 1994. Delving more specifically into the Queensland legal system, in the case of Gamblin v State of Queensland 2018, an advanced care paramedic who had previously been dismissed for misconduct due to improper care of a patient filed for reinstatement. In order to be reinstated in Queensland, the applicant must provide sufficient evidence to prove that their original actions did not constitute misconduct, or that they have since learned from their mistakes and made strides to change and improve upon their behaviours. In this case, Mr. Gamblin was unable to prove that his actions were justified, and thus his reinstatement was rejected. Similarly, in the Queensland case Matthew v Higgins and Arnor, the applicant's conduct was found to be improper. Under Section 41 of the Ambulance Services Act 1991, the applicant failed to properly supervise a student while they were attending to a patient of the Queensland Ambulance Service, leading to the applicant failing to provide proper care. As the applicant's actions were improper, it is easy to argue this constitutes misconduct. In relation to Mr. Lauder's case, the panel governing the Scottish Ambulance Service found that the registrant's fitness to practice was currently impaired by his misconduct on the grounds of public protection and the wider public interest. Mr. Lauder was suspended for 12 months, which allowed the registrant to demonstrate that he had developed further insight and undertaken appropriate training. The outcome, however, did not include dismissal, perhaps due to the fact that Mr. Lauder had a good track record, employer support, and only a single act of dishonesty throughout his career. In conjunction with developing insight into his actions and how it impacted his patients and the profession as a whole, the decision not to dismiss him was justified. It is imperative that each registrant is thoroughly examined to determine whether the allegations placed are justified. AHPRA is in place to distinguish between those who are fit to practice in their profession and those who are not. In Queensland, it would be in the best interest of the greater public for Mr. Lauder to be dismissed and ultimately suspended from practicing as a healthcare professional. AHPRA works to protect professional titles through ensuring healthcare workers get a proper trial and vet unfair claims against workers. Had this been a Queensland case and APRA been Mr Lauder's governing body, he could have obtained advice from the organisation. However, following the facts of the case, he decided not to, as he was rethinking his role in the workforce. Practitioners have substantial time prior to the trial so they can consider the allegations and prepare their responses or arguments. In deciding against this, Mr Lauder has left himself to be judged solely on the reporting of his actions. In summary, there are clear breaches of misconduct on Mr Lauder's behalf which ultimately led to his suspension from the Scottish Ambulance Service. Through drawing upon similarities and differences in legalities between the Queensland legal system and that which is upheld by the Scottish Ambulance, Mr Lauder's case and outcome can be more thoroughly understood. The laws governing paramedics in Queensland place significant focus on a professional's fitness to practice. Put simply, Mr Lauder endangered and compromised patient safety and also failed to consider patient outcomes, relevant clinical assessments and responsibility for students' actions. Given APRA's role in regulating the professional titles of healthcare workers based upon morals and clinical decisions, it is agreed that should Mr Lauder have been a practising professional with the QAS, the ethical and just outcome would be a suspension. As qualified paramedics in Queensland are now recognised as a registered profession under APRA, correctly and thoroughly understanding what it means to be fit to practice greatly contributes to both patient safety and appropriate professional conduct in clinical settings.